Hello, and welcome to the Preventing Sexual Harassment Training. I'm Byron Decato, Director of Louisiana State Civil Service. I would first like to thank each of you for your service and dedication to the state and the citizens of Louisiana. Your commitment to excellence helps us make a difference every day for every citizen. You can also make a difference in keeping our workplace free from sexual harassment through education, awareness, and prevention. This training was developed with these goals in mind and designed to provide you with guidance in ways in which you can help. As this cultural and legal change evolves, the Louisiana State Legislature continues to explore and refine ways in which sexual harassment is addressed in our state. For 2020, this includes a key new provision of law. Act 413 of the 2019 Louisiana legislative session provides that when there has been a determination that sexual harassment has occurred, the alleged harasser may be required to reimburse the state for all or a portion of the monies paid in settlement or to satisfy a judgment. If suit is filed on behalf of the state to enforce this right, the alleged harasser may also be responsible for the state's attorney fees and cost. Simply put, this new law furthers the extent to which individuals may be held liable for committing sexual harassment and allows for those individuals to be held financially responsible for their actions. I trust you will find the following training both informative and helpful. It is up to us as employees to recognize and address harassing behaviors and to take the steps necessary to create a safe and welcoming workplace.
Upon completion of this course, you will be able to define sexual harassment, explain the impact sexual harassment has on individuals and on our workplace, discuss the components required in an agency's policy on sexual harassment, apply strategies to help eliminate sexual harassment in our workplace, respond appropriately if you are harassed or witness sexual harassment. Explain how harassment complaints are handled. Disclaimer: this training has been created in accordance with Act 270 of the 2018 regular session. This training module has a minimum completion time of 1 hour.
The great state of Louisiana, home to fantastic food, festivals, families, and friends. As residents, we take pride in our state, our heritage, and our culture. We are, however, more than residents of this great state. We are the team Louisiana has employed to ensure that our state continues to thrive. You have been carefully selected as an employee because you have something to offer our state. As such, you possess the ability to help our state, our workplace, overcome unwanted hurdles. As I know you will agree, sexual harassment threatens our ability to create the open, welcoming, safe, and respectful workplace that everyone deserves. Together, we can and we must stop the damaging effects of sexual harassment, giving everyone a chance to thrive in our state and in our workplace.
The Equal Employment Opportunity Commission, EEOC, is the federal agency responsible for enforcing federal anti-discrimination laws. The EEOC defines harassment as a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. Title VII is a federal law stating that it is illegal to discriminate based on protected characteristics or to retaliate against someone for filing discrimination charges. Under federal law, protected characteristics include race and color, national origin, gender, age, disability including pregnancy, religion, citizenship status, and genetic information. Louisiana also includes the sickle cell trait. Now that we know a little about Title VII, we want to know, what exactly is sexual harassment?
Sexual harassment is kind of exactly what it sounds like. It can be unwelcome sexual advances. It can be unwelcome requests for a sexual relationship. It can be unwelcome touching or even just verbal communication of a sexual nature that starts to affect someone's job performance or creates a hostile work environment.
It is unlawful to retaliate against an individual for opposing employment practices that discriminate based on sex or for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or litigation.
It's really important to alleviate the fear of retaliation because, for one, retaliation is illegal. People who come forward with complaints are protected. Also, we want our employees to feel comfortable and confident to know that we stand behind them. If they are sexually harassed, we will take care of that and make sure it doesn't happen or continue to happen again. So we encourage our employees through training, through policies, through speaking publicly to them at our meetings to come forward if they are harassed or feel that they've been harassed.
Sexual harassment affects multiple people each and every day. The EEOC receives thousands of reports per year. In 2015, the EEOC received 26,396 charges for sex discrimination, including sexual harassment. This information was provided by EEOC.gov. Diving deeper into what these numbers mean for Louisiana has uncovered the big question: is sexual harassment really a problem in today's workplace?
Sexual harassment has historically been a problem in a workplace. If you think about instances such as Anita Hill and more recently the Me Too movement, sexual harassment clearly is a problem, and I believe it's being brought to the forefront as people begin to embrace the concept of what it means to be harassed or to endure harassment.
Of course, in light of the Me Too movement, you will find that sexual harassment is now becoming more prevalent. Women and men are now feeling more armed and able to exercise their rights in letting people know that they have been violated.
People don't understand what appropriate boundaries are sometimes, and as administrators, we need to ensure that we're clear as far as what expectations are relative to sexual harassment, what's tolerated and what's not tolerated.
Or to also be able to interpret their own experiences in a way that is able to be shared and communicated with other people that they consider to be a safe space.
Now that we know there is a need to address this sensitive topic, we must look at the negative impact sexual harassment can have on individuals, on agencies, and on the state as a whole.
It makes me sad to know that someone I know and respect may have or may be dealing with this.
What's the point? Then I say, you have to stand for something. Someone has to make a stand if this is going to stop.
It's like you're back on the playground again. There's always that one bully. Only we're not kids. We're not fighting over toys or who gets to go down the slide. We're fighting for our dignity, for basic human kindness and respect.
I think that sexual harassment in the workplace does change the environment. Employees, those that are witness to the sexual harassment, feel that there's been a trust that's been broken, that the environment is not respectful, they can't be trusted. So it really tarnishes how the employee feels about the place that they work.
It creates a dynamic that leads to a uncomfortable environment, if you would. The desire is to create a workplace that everyone feels comfortable and safe. And when sexual harassment occurs, that employer is now remove that protection from the employee, and they don't feel safe and comfortable. And if they're not safe and comfortable, then their productivity lowers.
So when there's an allegation of sexual harassment, I think that you can break it down into a couple of things. Obviously, just the fact that there is a conduct going on of a harassing nature in and of itself is a problem. And it can have all sorts of consequences for the organization in the work environment. It can have consequences, obviously, legally and financially, if the individual who's the victim of the harassing behavior makes a complaint. When you layer that on with the fact that once there is a complaint made, there's going to be an investigation. There could be a claim, as I mentioned, or some litigation that results in it. So all of those can have tremendous impacts on an organization and certainly the state to make sure that there's a safe working environment, but also that we don't put the taxpayers in a situation where they are being held responsible for the actions, the inappropriate actions of an employee. All of those are considerations that have to be well considered.
This discussion about potential impacts also poses the question, how could or do false accusations of sexual harassment impact the workplace?
False accusations of sexual harassment in the workplace are statistically minimal. However, negative information being spread in any organization can impact someone personally and professionally.
A lot of times, false accusations of sexual harassment are worse than actual allegations of sexual harassment because it lends us to the belief that a lot of these allegations are false, and it only tends to perpetuate that line of thinking.
The real person that's getting harassed doesn't feel that they're going to be believed, that they think that they can't report it because others have done so and done so falsely. So they don't feel that they have a voice and sometimes won't report it because people talk about it, people make light of it. They really just don't believe it.
Telling the truth is paramount. If you are not true in what has transpired between you and another individual, you can damage that person's psyche, you can damage their reputation, you can damage their emotional stability.
There are two main types of sexual harassment: quid pro quo sexual harassment and hostile work environment sexual harassment. According to Merriam-Webster Dictionary, quid pro quo is a Latin phrase meaning something that is given to you or done for you in return for something you have given to or done to someone else. This phrase is more commonly referred to as this for that.
Essentially, it's an implied bargain for sexual activity or favors. Quid pro quo sexual harassment occurs in the workplace when a person in a position of power or authority, like a supervisor or a manager, pressures an employee to engage or to consent to sexual activity in order to gain a job-related reward or to avoid further a threat of discipline or a threat of injury.
While quid pro quo harassment usually involves a supervisor or manager, the harasser could also be a vendor, customer, employee from another department, or any person who has some job-related power over an employee.
Quid pro quo can happen even if it's not a supervisor relationship. It could be a coworker, a vendor. A coworker, for instance, could be maybe your procurement section. They may say, if you do this for me, I may buy you something extra to make your job a little more nicer. Or IT could say, if you do this for me, I will give you the best computer that we have. So it doesn't necessarily have to be a supervisor relationship.
Agency harassment policies strictly forbid quid pro quo harassment. Hostile work environment sexual harassment exists when behavior of a sexual nature creates an offensive or hostile environment that interferes with an employee's work, affects an employee's work performance, or makes an employee feel intimidated, degraded, or abused.
A hostile work environment doesn't happen overnight. It happens, and it doesn't necessarily have to happen to that person specifically. It could be some people over in the corner talking about the person in another section or another agency, or even nobody in specific, just a gender, and it makes that person feel uncomfortable, and it makes them, over time, it's repeated actions that make that person build rage or hostility, and the person can explode or just feel shut down and not be able to perform their job.
Sexual harassment allegations can create a hostile work environment. We've had staff that were literally afraid to come to work because of harassment, because of incidents that they witnessed while they were not involved, but they were still a party to actually see what had happened. So from that standpoint, it creates issues for staff that are impacted and for staff that are not impacted because of the uncomfortable nature a lot of times of these situations.
Not all situations resulting in a potentially hostile environment are of a sexual nature. There may be circumstances where actions taken, regardless of the recipient's feelings toward those actions, are necessary.
If a supervisor reprimands or counsels an employee for poor work performance, that's not harassment. Supervisors have the responsibility to correct poor performance.
There are other instances of a non-sexual hostile work environment.
Personality conflicts between employees can create a hostile work environment, but that's not necessarily a sexually harassing hostile work environment. Normal workplace friction is not sexual harassment.
Physical conduct that can create or encourage a hostile work environment includes, but is not limited to, unwelcome physical contact.
Unwelcome physical contact could be done in many different ways. Rubbing up against somebody, accidentally touching somebody. A lot of times we have staff that have issues with people invading their personal space, and it may be for personal issues, it may be cultural issues, it may be religious issues. We also have staff that just don't want to be touched by any other staff, whether it be male or female. And they don't have to give a reason. They just need to put the staff on notice that I don't want to be touched, I don't want you in my personal space, and that it really makes me uncomfortable.
Unwelcome physical gestures could also create a hostile work environment. Unwelcome physical gestures include obscene hand movements and facial expressions, as well as unwanted staring or leering. Another potential cause of a hostile work environment could be displaying or distributing offensive pictures or objects. This includes pictures or jokes sent via electronic media such as email or text messages, as well as pictures or objects displayed in the workspace such as pornography.
It's always best to let the harasser know that the behavior that they've exhibited is not appreciated by you, nor do you feel that it's respectful to you. You need to be specific about what behavior that they have exhibited that you did not appreciate. And it's okay to say, I don't appreciate what you said. I don't appreciate how you looked at me. I don't appreciate the images that you've shown me on your phone or on text or in social media. You need to be specific what behavior that you felt was not respectful to you, and that the person needs to be aware that that behavior needs to change and that you're not going to accept it.
In addition to physical conduct, verbal conduct can create or encourage a hostile work environment. Verbal behavior that can create or encourage a hostile work environment may include, but is not limited to, unwelcome verbal comments, including sexually explicit or offensive comments, jokes, and stories, or repeated and unwelcome requests for dates. Derogatory or degrading personal comments, including comments about another's physical attributes or personal life, can also contribute to a hostile work environment. Additionally, any offensive and/or sexually explicit language, including radio broadcasts, could create a hostile work environment. Potentially hostile verbal behavior should and can be eliminated in the workplace. All of these activities are strictly prohibited by agency policies. Another type of sexual harassment not often considered or talked about is harassment based on gender stereotyping. In this type of harassment, an employee may be subjected to derogatory comments, slurs, or offensive jokes based on arbitrary standards of masculinity or femininity. Or they may not be offered a job because their appearance is not considered to be masculine or feminine enough for the job.
When it comes to gender stereotyping, one example comes to mind. if you had a female employee who was petite, possibly somewhat of the appearance of being frail, that she was applying and interviewing for a job that required lifting of heavy items. And in an indirect way, during the interview process, was told that she wasn't suited for the job. I think that that would be an example of gender stereotyping.
A well-known court case, Brenna Lewis versus Heartland Inns of America, involved a woman who was not given a promotion in her company because the manager thought she did not wear enough makeup or feminine clothing. The case was allowed to move forward to a jury trial. As the definition of sexual harassment shows, sexual harassment can occur in a variety of circumstances. Theoretically, anyone can sexually harass anyone else. When we think of sexual harassment, we often think of a supervisor harassing an employee. While that is one example of sexual harassment, there are other circumstances of harassment.
The harasser can be a victim supervisor, an agent of the employer, a supervisor in another area, or a coworker. The harasser can also be a non-employee.
A non-employee is anyone who does not work for your agency. This includes vendors, customers, and independent contractors. Sexual harassment committed by a non-employee to an employee may also be referred to as third-party sexual harassment.
Say, for instance, a delivery person that comes in. The employer has to protect their employee. If that person does something egregious to them, you have to let them know that behavior is not accepted in our environment. And then you would let their employer know, hey, just so you know, this occurred today, and can you make sure that it doesn't happen again?
The victim does not have to be the person harassed, but could be anyone affected by the offensive conduct.
So even if you don't engage a person directly in any type of behavior, any type of discussion, don't think that they can't be offended or they can't be have a feeling that they're actually being harassed. They can be just through actions or just through behaviors or discussions of other employees.
The victim, as well as the harasser, may be a woman or a man. The victim does not have to be of the opposite sex. This type of harassment is often referred to as same-sex sexual harassment.
It eventually made it hard for me to even function at work. I dreaded being in an office or even having to work with her. I hated that because I saw her as a friend. I didn't want to think of her as a sexual harasser.
A survey conducted by Cosmopolitan of 2,235 working females reveals that 1 in every 3 women has experienced sexual harassment while at work. The harassers varied from clients to vendors to managers. Some of these women reported that sexual harassment doesn't always appear the same way it is portrayed in film. Rather, it can be quite difficult to notice sometimes. One person witnessing the act might not think the behavior is harassing. But what about the recipient? And how does the recipient respond? The same study showed that only 29% of the women harassed reported the harassment. The majority of victims did not report harassment.
Many times employees are afraid to come forward. For different reasons. Maybe they are an employee that doesn't have permanent status with state government, and they are fearful under probationary status that they may lose their job.
In a separate study done by defense law firms, both men and women were asked about sexual harassment at work. The result came back with 10 to 20% of men experiencing sexual harassment and 40 to 70% of women experiencing sexual harassment while at work. 69% of those targets took no action.
It takes a great deal of courage to be able to come forward publicly or privately to share instances of sexual harassment. And from that space, it's very important that all parties involved create a supporting environment that is free of blame, that's free of bias, and that is also supportive for both males and females who have perceptions or real experiences where they have been harassed in any way.
Hostility isn't always in the form of violence. For each victim who does not report sexual harassment, a potentially hostile situation may be imminent. Resentment, anger, shame, and a number of other emotions can be dangerous, especially when the reason for these emotions still exists. Many people accused of sexually harassing another defend their behavior by saying they were only joking and didn't mean anything by it.
The courts have said that it's not the intent of the person or the jokes that they're saying, it's the way the person perceives the jokes or the words that are coming out of somebody's mouth. So it's not necessarily the intent, but how the victim perceives this.
Most sexual harassment takes place at the employee's place of work. However, harassment can happen off-site too.
I was at a conference for work when I was suddenly approached. It was very uncomfortable. I just couldn't believe it was actually happening to me.
Sexual harassment can take place anywhere, including but not limited to temporary work sites, including a client's or customer's work site, at restaurants or other places where work gatherings take place, while traveling for work or with coworkers, at conferences, trainings, or other events.
Harassment can also extend outside of the workplace. So if you work with that individual and they approach you in a very informal setting, you can still tell them, I appreciate it, but I'm not interested.
You may be wondering how sexual harassment could appear in the workplace.
Sexual harassment in the workplace can look like touching somebody who doesn't want to be touched, listening to a sexually explicit song, or a DJ who's saying all type of outlandish things.
Sexual, suggestive comments or innuendos, images of a sexual nature, jokes or comments that talk specifically about an individual.
If there is a video being watched, or there is music, or just things that pop up on social media that even they're not things that you post, but something that you might want to show one of your employees that you think is funny, that fits within your sense of humor, but it might not be so for someone who you work with.
Over the past few years, social media has changed the way individuals and organizations view or respond to claims of sexual harassment.
Social media has really revolutionized the topic of reporting sexual harassment. This is an instantaneous reveal of information that is shared in a broad spectrum audience, and it has very consequential impacts.
Social media has totally changed the work relationship between employees and their co-employees and their supervisors. And I think it probably, for sexual harassment, it's probably been a double-edged sword. On the negative side, it certainly creates lots of more opportunities for people to interact with employees, and sometimes in an inappropriate way. And a lot of times people aren't as careful and as guarded in their interactions with social media as maybe they would be one-on-one. And that's a strange dynamic, but it's true, and we've all seen that. I think one of the things that maybe is on the plus side, on the positive side, is that social media does give the ability for victims of sexual harassment to find a voice.
It is important that you manage your social media life. You should treat your coworkers and other professional contacts online the same way you do in person.
It's very important that individuals are mindful when utilizing their personal social media accounts to communicate with others, particularly those who are their colleagues, because there is a very, very delicate manner in which individuals can misinterpret something that's in writing, or the person who is not being appropriate can also intentionally or unintentionally cause harm or cause someone to feel uncomfortable. And so being intentional about social media and the utilization of social media is so important.
If you wouldn't do it in person, don't do it online. You may not want to friend your coworkers or connect with them on any platform that is not professionally based to protect yourself from scrutiny and opportunities for questionable interactions.
People need to be mindful when they're off work, and what they post on social media does have an impact in the workplace, because people are able to get out and see that. And if you put something up and somebody sees it, they can always take a screenshot. I mean, we've had to take disciplinary action on staff just behind what they've placed on social media, in that it was so inappropriate that it really put themselves and it put the agency in a bad light.
Sexual harassment in the workplace can be prevented. Awareness is key. As of January 1st, 2019, Act 270 of the 2018 regular session made awareness and prevention steps a priority statewide.
So Act 270 was a really important step forward for the state in that there's been a lot of discussion both in the state and all across the country about sexual harassment. And this legislation was both in response to that, but also in response to a task force that the governor set up to create a set of guidelines and policies about sexual harassment. So that legislation essentially did two important things. The first is it makes sure that all state employees have a mandatory, at least a minimum hour of education about sexual harassment every year. The second thing that it did, and perhaps even more importantly to that, is it makes sure that all state agencies adopt a policy about sexual harassment.
Act 270, the law requiring preventing sexual harassment standards, declares that each agency policy shall at minimum contain a clear statement that unwelcome sexual advances, requests for sexual favors, and other verbal, physical, or inappropriate conduct of a sexual nature constitutes sexual harassment when the conduct explicitly or implicitly affects an individual's employment or the holding of office, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment, and shall not be tolerated.
An employee should report harassment anytime they feel like something has made them totally uncomfortable with being in the same space with someone else. If someone has made you uncomfortable to a point where you feel like, well, I can't do my job because this is on my mind, what this person has done, or I don't feel safe in the same space with this person. You know, I can't focus on what I'm supposed to be doing because of what this person has done.
The policy in place must also contain a description of the behavior the agency defines as inappropriate conduct, including examples. The policy must outline an effective complaint or grievance process that includes taking immediate and appropriate action when a complaint of sexual harassment involving any public servant in the agency is received.
When a supervisor receives a complaint of harassment, their responsibility is to listen to what the person has to say. It's not their responsibility to determine if it's real or not. Their responsibility is to listen to what they have to say. Based on the feedback they receive, they need to contact Human Resources, and Human Resources will partner with them to thoroughly investigate the incident. Our responsibility is not to be judge and jury. Our responsibility is to investigate it thoroughly and make decisions based on what we learn and take action based on that information.
The complaint process shall detail who may make a complaint, to whom a complaint may be made, and shall provide for alternative designees to receive complaints. Actions taken on the complaint shall be documented. The policy shall contain a clear prohibition against retaliation against an individual for filing a complaint or testifying or participating in any way in an investigation or other proceeding involving a complaint of sexual harassment.
Retaliation is not only unethical, but it's illegal. Retaliation could look like anything from mocking someone, harassing him or her for reporting, or suggesting someone will lose their job, suggesting that someone will pay if they report. Retaliation could also be threats of demotion or threats of bodily harm.
Act 270 also requires that the policy must possess a statement apprising public servants of applicable federal and state law on sexual harassment.
Employees must take sexual harassment training each year, and anybody who is a supervisor or who may investigate or receive a complaint has to receive additional training. And this is to educate employees on what sexual harassment is, educate agencies on how to handle these complaints. It's just to raise awareness and also to encourage employees and let them know that they're protected.
Being familiar with your agency's policy can help you prevent committing sexual harassment and will assist in guiding you through appropriate steps for responding to sexual harassment.
A lot of times, and one of the things we determined as the task force was meeting and the legislation was moving through the process, a lot of times employees don't even know where to go. What if I'm being harassed, who do I talk to? If it's my supervisor, who do I report to then? And so what was done after a lot of careful consideration is a set of uniform policies and guidelines was created. It's on the Division of Administration website. And so all the agencies in state government, and not just in state government, but beyond, are encouraged and mandated by this legislation to go and adopt a policy so that they can provide instruction to their employees on what is sexual harassment, how to deal with it, how to report it, and what sort of things are not going to be tolerated.
If you don't know where to find your agency's sexual harassment policy, you can check the agency website or intranet, check with your agency's HR office, check with your supervisor. In addition to knowing your agency's policy, preventing sexual harassment is possible with an increase in self-awareness and social awareness.
With the heightened attention to sexual harassment that's been in the media, that's been in government relations or commented, employees certainly have asked more questions about it. They've pondered about, has this been going on for a long time? I didn't believe this was still happening in the workplace. And unfortunately, it's still happening in some workplaces. So I do think people have become heightenedly aware that it still exists. I think people thought that it was gone or eradicated, but it certainly has brought it back into the forefront and has made people ask questions and made them kind of look internally. Has my behavior been such that perhaps it could be perceived as harassment or as inappropriate? When someone told me that what I said or did, they didn't feel comfortable with it, did I really make the necessary changes? And I think it's made employees just kind of do some self-reflection on some of the things that they have done and said. And I do think that employees have made some changes as a result of the heightened awareness.
Consider your actions on the job. Inspect your area closely. Do you notice anything that could be considered potentially offensive? While it can be easy to get caught up in your personal routine, pay attention to the role your presence plays in your workplace, our workplace, and what you can do to prevent sexual harassment. Once you are aware of your own presence and influences, look around at others and consider what mindsets, items, or behaviors they may bring to the workplace. How are they influencing the work culture?
Employees should always foster respectful and safe work environments. Employers should define appropriate behavior. It is also important that there is a clear setting of expectations by both employers and employees, and addressing all allegations with concern and expediency are very important as well. Sexual harassment is to be clearly defined, and it's also important for employees to demonstrate clear consequences for unacceptable behavior.
If, upon reflection, you realize that you or others may be creating a sexually harassing environment, take positive steps to change it.
I think if you treat people with respect at all times and just think before you speak, that's a big factor, a big way to avoid any type of misunderstandings.
Obviously, the way that you prevent yourself from committing sexual harassment is to not have sexual conversations, to not have sexual advances, to not say things that are inappropriate or that you would feel uncomfortable if somebody knew what you were telling your co-employee. If you don't do that in the first place, then you're very likely not going to be accused of sexual harassment. And so people should always be on guard for saying things that might be deemed or interpreted the wrong way. And you know, that goes from interactions on a daily basis, it goes to social media, it goes to if you happen to meet your employees, your fellow employees out for a drink after work, all of which is not to say that you can't have normal, productive, healthy relationships in the office, but it is something when you have to be careful to make sure that you're not creating an environment that's uncomfortable for people to work around you.
Do not display sexually suggestive objects or pictures. Do not post sexually suggestive jokes or pictures on bulletin boards or send via email or text messages. Refrain from making sexually suggestive, derogatory, or offensive comments to or about others in the workplace. Remove other sources of offensive materials, such as radio stations playing songs with sexually explicit lyrics or offensive disc jockeys. A good rule of thumb to follow in this regard is that if you have any doubt what you say, write, or post could offend another, don't do it.
Pay attention to your surroundings. Pay attention to the dislikes and likes of each person. If you feel like something that you're about to say or do may offend, or you don't feel quite right about it, don't say it. It's best not to say anything, and always treat people with respect.
Sexual harassment is not tolerated in any agency in the state of Louisiana. Laws and policies are in place to help you deal with and stop harassment and to protect you from retaliation. If you believe you are a victim of sexual harassment or you have witnessed sexual harassment, you should take action to stop it.
If sexual harassment is not reported, there's nothing that we can do to prevent sexual harassment from occurring. It has to be reported. It has to be reported as quickly as possible, and it has to be taken as seriously as possible by the staff that it's reported to. If it's not reported, it's just like documentation. If it's not reported, it didn't happen, and there's no way for us to be able to look into it and see what happened and address the issues that are causing the harassment.
I didn't know what to do. If I did nothing, it may or may not eventually stop. If I reported it, it felt like my whole world could unravel. It affected my performance, my mood, even my appetite. I was just lost.
Ideally, your first step will be to tell the harasser to stop.
The first thing that you should do if a person harasses you and you want them to leave you alone, say that. Leave me alone. Be emphatic about it. Say no. I do not appreciate the activity, the movement, the touch, the voice that they have said or what they have said and how they have said it, or what may be offensive to you in any type of manner.
Sometimes harassers don't realize that their behavior harasses, intimidates, or upsets you. Telling them will often cause them to reevaluate and change the inappropriate behavior.
Workplace morale is very important. Productivity, the camaraderie. Workplace is like a second home to many of us. We spend oftentimes more hours at work than we do at home. We go home just to go to sleep. So when you're around these people every day, you develop a relationship that you want to feel comfortable enough that you can engage each other in an amicable way without being offensive. And so it's important to gauge how you correlate and the dynamics and communicate with one another so that you can always be respectful. And there's nothing ever wrong with asking a person if you were offended. so that you can know how to change your conversation that you have with them.
If you feel you cannot confront your harasser, or you do confront the harasser and the behavior has not stopped, report the harassment to your supervisor, your HR, or the next person in the chain of command.
I eventually spoke with someone in HR, and I was relieved to have taken a first step in ending this harassment. I was so nervous, very worried, but relieved.
Depending on agency policy, supervisors may investigate harassment complaints themselves, or they may be required to report the harassment to the agency's HR office, where it will be investigated.
Many times the supervisor themselves will have taken the liberty of doing the investigation. And when I say doing or conducting the investigation, what I mean is they will gather statements, possibly interview the employees, and then they will provide our office with that information prior to us becoming engaged in the process.
Once a sexual harassment complaint has been filed, there will be an investigation of the complaint. How this investigation is conducted depends on agency policy. You will likely be asked to answer questions in an interview or in writing, or both, about the harassment.
We obviously want to make sure if someone's making a complaint that they can have as much documentation or evidence for the investigator to really make a firm determination as to what happened. We also want to guard against the possibility that someone is accused unjustly.
Who harassed you? What was the harassing behavior? When did the harassment happen? How often were you harassed? Were there any witnesses? These are all potential questions you will need to answer when reporting sexual harassment or participating in an investigation of harassment.
When they're ready to report that issue of harassment or that incident of harassment, they need to be able to tell whether it's a supervisor, a manager, a member of management, or human resources. They need to be able to say who did it, who was the person that harassed them. They need to explain how it happened. They need to explain when it happened, what occurred when it happened, how did that person respond to it, how did you respond to that harassment. Basically, the who, what, when, where, why is what you need to be able to provide in order for that harassment incident to be fully reviewed and investigated.
Supervisors have an obligation and responsibility to listen to your complaint and to take it seriously. If it is your supervisor who is harassing you, you will need to report the harassment to someone else.
We certainly don't want to put people in the situation where they have to report their supervisor's conduct to their supervisor. And again, all of that should be something where there's a clear communication in the policies about who it is that you should report to, who it is you should report to if the person that's harassing you is your supervisor.
All agency supervisors are required to treat harassment complaints seriously and to follow agency policies when dealing with them.
An employee should report harassment immediately. Immediately. Do not waste any time. You find that supervisor, and if that supervisor isn't available, go to HR. HR is full of people who are accountable and professional that know the standards that should be met to establish whether or not some type of violation has occurred.
Sharing information about harassment experiences may be embarrassing or difficult. Answering all questions fully and honestly, however, will help the investigation reach a fair and timely conclusion.
Employees who come forward to talk about their sexual harassment or any type of harassment are first of all embarrassed, uncomfortable, scared, not sure what's going to happen. So it's very important for HR or your supervisor or anybody that they're talking to assure that person that we take them seriously.
The complaint will be handled confidentially to the extent possible.
One of the first things that I tell them when you come to me and you're reporting something, confidentiality is always taken seriously, and that's one of the first things that they know when they report something is it's confidential and it's taken seriously.
we need to make sure that there's a safe environment for people to come forward and make a complaint without fear that somehow just the fact that they are making a complaint will be widely known in the office, and that their name will be put in the newspaper or things like that. We need to make sure that there's not a chilling effect for people to be able to come forward without fear of that.
To effectively investigate or process a sexual harassment claim, the people responsible for investigating must be informed, and the accuser and accused, as well as witnesses, must be interviewed.
Dates, times, witnesses, be very specific as to what was said and by whom, and if it was directed to a particular individual. Those are very key elements that we need to know when preparing reports and documenting findings with regards to investigations that are conducted.
It may be difficult to act impartially toward an employee who has filed a sexual harassment complaint against you or another employee, but it is necessary and required by both law and agency policy.
If you're accused of sexual harassment, for one, take it seriously. Approach the matter with a serious and respectful attitude. Listen to the complaint carefully. Try to see the questionable behavior from the accuser's point of view. Remain calm. Listen carefully. That's the main thing, because when you are accused, you automatically become defensive. Try to remain calm. Do not try to approach or explain your actions to the accuser. Make sure you cooperate. Be honest and answer factually. Don't try to interpret things. Answer with facts. Respect confidentiality. Remember, people's reputations are at stake, including your own.
The accusers, accuseds, and witnesses' supervisors, and perhaps those higher in the chain of command, need to know that there is an investigation going on, if only so they know why these employees need to leave the work site for interviews or investigations. If disciplinary action is involved, the appointing authority will also need to be included in the investigation.
If it's a supervisor that's doing the harassing, the agency can be held liable for that because the supervisor is acting in an official capacity of the agency. So it's very important to at least give the appointing authority a heads up just so that they know what's going on.
Violating confidentiality can have serious consequences on the investigation. Supervisors and others are expected to maintain confidentiality outside of the investigation, as should any participants involved in the investigation.
Confidentiality in complaints of inappropriate workplace conduct is really important. It's delicate within state government, within public employment, because it is something where all of us have different roles to play in terms of the transparency of state government. And so we don't want there to be a situation where there's a lack of awareness of the public about what's going on. That's why in this most recent legislation that was passed, there's mandatory reporting about what is going on and the number of complaints, et cetera. But at the same time, we all know that there needs to be an ability for someone to come forward in a confidential way where they won't, just by the very nature that they reported inappropriate conduct, that their name's on the front page of the paper.
Employees are protected from retaliation by both federal law and agency policies when they file a complaint about sexual harassment or participate in a sexual harassment investigation. Retaliation from a supervisor or employer could appear in adverse employment actions such as termination, demotion, or failure to promote.
Retaliation can come in many forms. It could be not receiving a good evaluation on their annual evaluation. It could be moved to a shift that they may not be wanting to be moved to. It could be moved to a post that might not be as desirable as the one that they were in. It comes in many forms and it can come in many ways. Again, if the staff report sexual harassment and they feel like they're being retaliated against, we need them and we encourage them to come forward and be as specific as possible about what they feel that retaliation is.
It essentially makes the victim twice the victim, because they first are the victim of the harassment, and now merely because they complain, which we would hope and expect and want the employee to do. Instead, now they're victimized again because they're demoted or fired or transferred, or even it doesn't necessarily even have to be a demotion. It can just be a situation where they are moved out of the office in a way that they were not wanting or weren't welcoming.
Retaliation complaints and lawsuits are on the rise, accounting for 36% of all court cases the EEOC prosecuted in 2009. It is important to note that an accuser can lose his or her harassment lawsuit and yet win a retaliation lawsuit.
It is important that we as a state make it clear that the state is committed to creating a working environment free from sexual harassment and discrimination for everyone. It is important that we all create a culture, a community of caring within the state that provides a safe space for individuals to come forth without fear of retaliation and without fear of being labeled.
We want to make sure that your environment is just as pleasing to you at work as it would be at home or anywhere else. We want the state of Louisiana to be a harassment-free place. We want employees to feel that they can come to work and not be subject to harm in any type of form.
If employees, if supervisors, if agency heads create that environment, then that'll put those agencies in a much better place to prevent harassment in the first place.
I hope you found this training both valuable and educational. Thank you again for your commitment to our state. And thank you for maintaining a workplace that fosters a sense of respect, equality, and unity. It begins with you. Be proud of your public service. Be prouder to stand up and prevent sexual harassment.
Every day for every citizen.